I've developed my own manner of analyzing a drunk driving case, and it's what I call the 6 factors of drunk driving defense. The first and most important factor is my client. My clients are people who are creative, productive, pro-social people who've been successful in life and may have made a mistake or may be falsely accused. In any event, when a person walks into a courtroom, the image that they present, the person that they are, is judged by all the people who are looking at them, the judge, the prosecutor, the jury, and making sure that the excellent qualities of my client are conveyed to the people in the courtroom is the first step in effective drunk driving defense. The second step in effective drunk driving defense is telling my client's story. And I don't mean explaining the evidence. What I mean is coming up with a theme that explains how a decent person got into this mess. It could be as simple as an incompetent police officer or the fact that my client was not drunk, he was sick. The next thing we look at is the behavior of the law enforcement people from beginning to end. And this starts with the moment that the law enforcement person directed his attention to my client, whether the person was stopped by being pulled over or whether the person was, say, sleeping in his car or taken out of his house, or however law enforcement came into contact with my client. I want to analyze this. The Constitution protects people from unreasonable interference by police, and yet a lot of times police act on hunches. Now, that's effective law enforcement, but it's not lawful. And we start with looking for ways to challenge that initial contact, the initial stop and the initial detention. There are published federal standards that exist for the manner in which the police need to conduct a drunk driving investigation. Many police officers take a course and are certified in drunk driving investigation. A few lawyers are certified. I'm certified in drunk driving investigation. We have to make sure that the police follow the correct procedures for the manner in which they administer the field sobriety tests and the manner in which they arrest a person, the way that the person is advised of their rights regarding a breath, blood, or urine test, and so on. If there's any flaws in that procedure, we challenge it. The fourth factor that I look at is the driving. First of all, many times my clients aren't driving or operating at all. I've had people arrested while they were sleeping in their vehicles, doing the right thing. Sometimes they're driving, but they're on private property. Even if my client is pulled over for some driving offense, let's say speeding or a minor lane deviation, that doesn't necessarily mean that their driving was impaired by alcohol. We have to take a careful look at that, and we have to be able to demonstrate that the driving is not evidence of impairment. The fifth factor that I look at in a drunk driving case is my client's behavior, appearance, and demeanor at the time of arrest and throughout his contact with law enforcement. Law enforcement people will try to magnify the mistakes a person makes, say on the field sobriety test or any little loss of balance. It's important to look at the total picture. It's important to look at how you were able to identify yourself, know where you were going, produce your driver's license, get out of your car, walk to the area behind your car where the field sobriety tests were administered, listen to the police officer's instructions, get in and out of the squad car, walk in and out of a hospital, walk in and out of a police station, and just generally how you appeared. If a person appears normal throughout the entire time that they're with a police officer, but screws up in some minor way on a field sobriety test, that's pretty good evidence that they are unimpaired. The fact is, even according to the federal government, about a third of sober people in this world cannot pass field sobriety tests. The sixth factor that I look at is the chemical test. Most people think the chemical test is the most important part of a drunk driving case, but I disagree. It is critically important, but it's not the most important piece of evidence. Breath tests can be false. Radiofrequency interference, mouth alcohol contamination, gastroesophageal reflux disease can all cause false high breath test readings. What most people don't realize is that blood tests can also be false. There are lots of things that can cause a false high test result in a blood test. If an alcohol swab is used on the subject's arm when the blood is drawn, there are situations where that can cause a false high test result. If the person is diabetic and the machinery is not properly calibrated, that can cause a false high test result. We've even seen situations where the laboratory lost or mixed up the blood with a different person. So, my advice is, if it's an important case, if it's important to you, if it's important to my client, the blood test results should be carefully analyzed. All the laboratory records should be scrutinized to see if there's any evidence of any error. Many people should plead guilty to a drunk driving case, and I have no problem with the lawyers who are experts in helping a person minimize the consequences in their life. But for those people who need to fight the case because of the consequences on their career or because of the jail sentence, they need to find a lawyer who's an expert in fighting a case, not just pleading a case.